This is Bloomberg Law with June Grasso from Bloomberg Radio.
Charging with the crime of murder in the first degree and other related charges. How do you plead this indictment, sir? Guilty or not guilty?
Not guilty.
Luigi Mangione pleaded not guilty to murdering United Healthcare CEO Brian Thompson in December of 2024. The public hasn't heard much else from Mangione until his outburst after a tense hearing setting the date for his state murder trial. As he was led out of the courtroom, Mangione shouted, "It's the same trial twice. 1 + 1 is 2. Double jeopardy by any common sense definition." And state and federal prosecutors have been engaged in a virtual tug-of-war over who will try Mangione first. And even the judges seem to be jockeying for position, with the state judge setting a trial date of June 8th, only after the federal judge set a trial date of September 8th. My guest is former federal prosecutor Robert Mintz, a partner at McCarter English. Bob, this is what you'd think of as a typical state murder case. A person was killed on the streets of New York City. It was investigated by the New York police in conjunction with the Manhattan DA. The federal government didn't get involved until 2 weeks after the shooting. I mean, why is the federal government trying him as well?
Well, you're exactly right. Murder cases are typically prosecuted in state courts. But in this case, federal prosecutors have said that he crossed state lines to stalk and ultimately kill healthcare CEO Brian Thompson, and that gives them federal jurisdiction to prosecute the case. The other reality of what's going on here is that this is a very high-profile case, and both the Department of Justice and the Manhattan DA's office both want to take a shot at trying this case. And that's why we're seeing a virtual tug-of-war between federal prosecutors and state prosecutors as to who is going to try this case first.
And both the state and the federal government overcharged Mangione, didn't they?
In both the state case and the federal case, judges dismissed charges before they even went to trial. That is something that is exceedingly rare. Most times prosecutors charge cases, the case at least goes to trial. The defense can make a motion to dismiss a charge at the end of the case once all the evidence has been presented. But it's unusual for prosecutors to bring charges and for a judge to decide based solely upon the law that those charges should not even reach a jury. Now, what we saw in this case was in the state case, Mr. Mangione was indicted on 11 counts, including 2 state terrorism charges that carried a sentence of life in prison without parole. The terrorism charges were dismissed in September. He still faces a second-degree murder charge, which could be 25 years to life, and 8 other charges. But those terrorism charges were dismissed by the state court judge. In federal court, we saw a similar thing happen where the federal judge also dismissed charges. In that case, Mr. Mangione faced 4 charges, 2 counts of stalking, a firearms offense, and 1 count of using a firearm to commit murder, which carries a maximum sentence of death. The federal judge dismissed the latter 2 charges and took the death penalty off the table in the federal trial. So in both cases, both federal and state, the maximum penalty is life without parole.
Now, you mentioned this tug of war. So the federal prosecutors and the Manhattan prosecutors are fighting over who gets to bring him to trial first. Normally, isn't that something that's worked out between the federal prosecutors and the state prosecutors?
Generally, prosecutors do try to work together. And what they do is they look at the federal case and the charges that are brought there. They look at the state case and the charges that are brought there. And they make a decision objectively as to which office has the stronger case and the higher likelihood of conviction. So in many cases, the state charges will have slightly different elements than the federal charges, and the penalties may be different. And so prosecutors will essentially agree which is the strongest case and lead with that. In this case, there seems to be no cooperation between the federal government and the Manhattan DA's office, and there is a virtual tug of war between the two, a battle as to which case is going to be tried first. We even saw at a hearing before the state court judge, the judge make a very unusual comment saying that U.S. prosecutors had essentially reneged on an agreement to let the state trial proceed first. So we're seeing here a very unusual situation where the federal judge has set the trial date for September 8th, which has prompted the state court judge to set a June 8th trial so that the state court case can proceed and be completed before the federal case goes to trial.
Yeah, aren't the judges also jockeying for position a little bit here? The federal judge said that she was proceeding as if the federal case was the only case unless one of the parties raised an issue with her. And the state court judge only sets a trial date when it looks like the federal trial may go first. How do judges usually handle it when there are competing trials?
Well, just like with prosecutors' offices, there is no set process by which state and federal judges must interact with one another in terms of setting trials or anything else. It's just usually a pattern in practice that there is some degree of cooperation and some understanding as to which case should proceed first. Here we saw a case where the state made the arrest first and the first appearance was in state court, but then the case got somewhat bogged down in state court, which has slowed that process. And in fact, there was a hearing in December, an important hearing regarding the exclusion of certain key evidence in the case. State prosecutors had argued that evidence from the backpack that was seized by police when Mr. Mangione was arrested at the McDonald's in Altoona should be admitted into evidence. It includes some key evidence, including a 9mm handgun, a silencer, a loaded gun magazine, and a diary, which, according to state prosecutors, includes some very incriminating statements made by Mr. Mangione, including a comment that Brian Thompson, the healthcare CEO, quote, had it coming, that you whack the CEO at the annual bean counter convention. So that's all very critical evidence to prosecutors. There was an extended hearing in December as to whether or not that evidence was going to be admitted into the state trial. The trial judge expects to rule on that decision in May. So the trial judge is taking some time to make what is a very critical decision about what evidence may or may not be admitted in the state court. Interestingly, the very same motion was argued in front of the federal judge, and the judge rather expeditiously ruled that all of that evidence will be admitted, denying the defense's argument that the police improperly searched the bag without a warrant. So that case, in some sense, is teed up and ready to go because that critical decision about what evidence may be admitted at the trial has already been decided in federal court. But state court prosecutors are adamant that their case should go first based on the theory that the New York Police Department investigated the crime and federal prosecutors only became involved 2 weeks after the murder. They say that they have a greater stake in the case, and in fact, it's only the state court case in which murder is being charged. It's second-degree murder. The federal charges are stalking charges, which carry a serious penalty because as a result of the stalking, a death occurred. But the murder charges are only the state court charges. And so state court prosecutors are saying that the case should be tried in state court first and that federal prosecutors should try the case only after the Manhattan DA's office completes their prosecution.
Mangione had an outburst in court saying this is double jeopardy, trying him twice. And the average person might look at this and say, that's right. He's accused of committing one crime, so why are both state and federal prosecutors trying him for that crime? But the law of double jeopardy isn't that simple.
Yeah, double jeopardy is a nuanced concept in the law, although it does have a common sense understanding. Basically, the Fifth Amendment precludes a person from being prosecuted twice for the same offense. But there are some exceptions, one of them being separate sovereigns. So, for example, if the federal government and the state government want to prosecute the same defendants for the same act, often that has been permitted. If you go back to the days of the civil rights movement, you may remember instances where a white defendant was tried for the murder of a black person and acquitted in state court. And then we saw federal prosecutors come in and essentially try the case again, alleging civil rights violations in federal court, and often could get convictions in federal court when state court convictions were not possible due to the makeup of the jury pool. So there is a long history of cases that are substantially similar being tried by different sovereigns, the federal government and the state government. Interestingly, on the federal level, double jeopardy is controlled by a 1932 case called Blockbuster versus United States that basically says that if there are different statutory elements of a crime, then you can be tried in separate cases. So in other words, if in state court you're being tried for murder and there's certain elements to convict somebody for murder, but you're being tried in federal court for violations of someone's civil rights, and there are different elements. In other words, prosecutors have to prove different facts in order to gain a conviction, then those are considered separate crimes and do not violate the double jeopardy clause. In New York State, however, the laws of double jeopardy are actually broader than the protection that the federal Constitution applies. And that's why we're seeing this interesting interplay between the Mangione defense and federal prosecutors saying that they would rather be tried in federal court first, because that will give them at least an argument that the New York State case should be blocked by the double jeopardy clause if the federal case proceeds first.
And the New York State double jeopardy law is why this fight over which trial goes first is so critical.
The New York State double jeopardy law is broader than the federal Constitution because under federal law, it looks at that blockbuster test, which is only looking at elements of a crime, while the New York State law looks at the second prosecution as the same offense or the same criminal transaction. And so it gives defense lawyers a chance to argue that even though the elements may be different, it's really the same offense and the same criminal transaction. In this case, my opinion is it will be an uphill battle for the Mangione defense team to convince a court that the New York State case is barred by double jeopardy, but there's no question that they will have a better argument if the federal case proceeds first, and then they are in state court arguing that the state prosecution is barred by the prior federal prosecution.
The defense attorney complained about the timing of the trials. Right now, they're 3 months apart if they go off as scheduled. Karen Friedman-Agnifilo told the state court judge, Gregory Caro, the defense will not be ready on June 8th, and Judge Caro said, be ready. Basically having to prepare for 2 trials at once does seem like a lot for one defense team.
Generally, judges are pretty solicitous of defense lawyers who say they need additional time to prepare for a trial, because what the judge does not want to have happen is they go through an entire trial and ultimately there's a conviction, for example, and then on appeal, the higher court looks at the case and decides that the defense was not provided adequate time to prepare for the defense, and the whole case gets thrown out and has to be retried again. So what we're seeing here is that the federal judge set that September 8th date for the federal trial, and the state court judge then counted backwards from that date in order to set a trial beginning on June 8th to allow that trial to be completed first. But as you say, the defense has strenuously argued that they will not be ready by June 8th, and that it is an undue burden for them to have to try the state court case only to then approximately 3 weeks later have to be sitting in federal court ready for another trial. What the defense is arguing is that the defense team is unfairly burdened because they have to prepare for 2 trials while prosecutors only have to prepare for 1 trial each.
Also, Bob, you talked before about how the state court judge hasn't decided yet about whether that critical evidence from the backpack will come in at trial. Judge Caro said he's going to make the decision by May 18th, but they're supposed to go to trial on June 8th, even though it's unlikely that the judge is going to suppress that critical evidence. Shouldn't the defense know that definitively while they're preparing for trial?
No, you're exactly right. And the federal judge has already heard argument on that very issue and allowed that evidence to be admitted. So I think we can expect the state court judge to rule the same way. It would be a devastating blow to prosecutors if the state court judge were to suppress that critical evidence, and it would make it much more difficult for them to gain a conviction. But nonetheless, from the defense standpoint, if you don't know for sure whether that evidence is coming in until the middle of May, and you've got to begin the trial in the beginning of June, it doesn't give you a lot of time to reset your case and to prepare for trial. And that's exactly what they're going to argue. So it's going to be very interesting to see whether these dates hold. One possible issue that could push the dates back is that if federal prosecutors decide to appeal the federal judge's decision to throw out the death penalty charge in the federal case, the state court judge said that he would likewise move back the start of the state court trial. So it's possible that the defense team will get additional time if federal prosecutors appeal that decision, but they will still have the argument that they have to try these cases in close succession and that they're not going to be adequately prepared to try both cases.
It'll be interesting to see whether either of these trials goes off as scheduled. Thanks so much, Bob. That's Robert Mintz of McCarter English. Coming up next, a superstar lawyer takes the stand at his criminal tax trial. This is Bloomberg.
And his face lost all expression. Said if you're gonna play the game, boy, you gotta learn to play it right. You got to know when to hold up, know when to fold up, know when to walk away, and know when to run.
Superstar Supreme Court lawyer Tom Goldstein took the stand at his criminal tax trial, going all in with extraordinarily high stakes, even higher than those at the multi-million-dollar poker games he played in. And poker is at the center of the trial, where Goldstein is accused of failing to report millions of dollars of his winnings while living a double life. As a member of the elite Supreme Court bar, who argued more than 40 cases before the High Court, and as a high-stakes poker player who won about $26 million in one series of matches and walked through U.S. Customs carrying a bag of nearly $1 million in cash. Goldstein knows the odds and the risks of taking the stand and opening himself up to cross-examination. But he's gambling that the jury will believe him and acquit him. Joining me is Bloomberg Law senior reporter Holly Barker, who's covering the Goldstein trial. Holly, start by telling us about how shocked the legal world was when Goldstein was indicted.
Tom Goldstein is a legal rock star. He's argued more than 40 cases before the U.S. Supreme Court, and he got there via a really unlikely route. Most people who make it to the Supreme Court, who are that kind of elite lawyer, also went to elite law schools, and they clerked for Supreme Court justices and so on. And he sort of got there through pure hustle. He would identify cases that he thought were likely to get taken up by SCOTUS, and he would cold call the people involved in the case and sort of pitch himself as the best person to take it up. And that's kind of how he built his career. He was also the co-founder of this thing called SCOTUS Blog, which is a website that sort of covers all things Supreme Court and became a really critical resource for people in the legal world. So when he was indicted last year on 22 counts, a combination of tax charges and allegations that he made a false statement in connection with loan applications, people were shocked. Those charges have been winnowed since they initially dropped. He is presently on trial for 1 count of tax evasion for 2016, 8 counts of aiding and assisting in the preparation of false and fraudulent tax returns for 2017 through 2021, 4 counts of willful failure to pay taxes, and that's for tax years 2017, 2019, 2020, and 2021, and 3 counts of making a false statement on a loan application.
How did he get into this world of high-stakes poker, and how much money did he make from playing?
So he'd had an interest in gambling. Like he would play poker with people in his law firm. He was interested in it. There was a period of time, I think in the early aughts, where poker was getting televised on TV and it was sort of gaining in popularity. He represented people in the poker world. One of his clients is featured heavily in this trial, incidentally. But it wasn't really until 2016 till he started playing these like massive multi-million-dollar hands. And that's sort of when things surfaced for him. And at trial, since he's taken the stand, it came out that in 2014, he had a pulmonary embolism and almost died. And after that happened, and I'm paraphrasing here, but he sort of felt like, I've got to seize life. And he went on to say, I may have overcooked that a bit, but that's sort of what led to his gambling in his sort of peak year in 2016, although it continued for years after that, with him mostly losing, but that's sort of where it started.
Just tell us about how high the stakes were. I mean, there was one instance where he carried a bag of cash, almost $1 million in cash, through U.S. customs from Hong Kong. I mean, what kind of money are we talking about?
Well, so the bag of cash, Goldstein says, was actually a loan from a former client who's very grateful to him for getting him off of criminal charges. It was a loan to pay his taxes, is what he says. But to answer your question, he played Alec Goras in 2016 and won around $26 million from him in a series of matches, to give you like a rough sense of the kind of dollar figures we're talking about.
The prosecution presented more than a dozen witnesses, from IRS agents and accountants to professional poker players and real estate moguls, and even one movie star, Tobey Maguire, of Spider-Man fame. Who were the most important witnesses for the prosecution?
I think the most important witnesses in this trial for the government were likely the accountants at Goldstein's outside accounting firm. His defense, there were errors on his tax returns. He's not disputing that. There were transactions that should have been characterized differently, either should have been characterized as income or shouldn't have been deducted as business expenses. And there's only a handful of them, 8 to be exact. And he's saying, look, yes, those should have been characterized differently, but it wasn't my fault. I was relying on my outside accountants and my firm managers. If they had any questions, I would answer them. I would answer them honestly and to the best of my ability. And they were the ones dropping the ball on this. So in that respect, getting the accountants on the stand to sort of explain what their process was and the efforts that they made to get his returns right was really important, I think, for the government. But I will say that the cross-examination of both of the accountants that they called was super effective. They highlighted mistakes that the accountants made that hurt Goldstein that he didn't catch in terms of his tax liabilities. And they didn't follow up and ask specific questions. Kravis, Goldstein's lead defense lawyer, just sort of took it apart.
I have to ask you about Tobey Maguire's testimony. He's known as a high-stakes poker player.
The testimony of Tobey Maguire was brief. Tobey Maguire took the stand to testify about a $500,000 legal fee that he owed to Goldstein after Goldstein helped Maguire recover significant gambling debt from Andy Beal, who's a billionaire in Texas. So he won $15.6 million in poker. About half of that was his. Beal didn't want to pay, so he hires Goldstein. Goldstein does the job, gets a successful result. Maguire gets paid, and Goldstein has this $500,000 fee. But instead of having Maguire send the fee to him, he had Maguire send the money directly to someone to whom Goldstein owed a gambling debt. So the idea was to have him come in and testify about this transaction that was ultimately misclassified. But again, Goldstein isn't disputing that certain transactions were misclassified or that he directed this fee from Maguire to somebody to whom he owned a debt. What he's saying is the way that it was classified on my tax return is not my fault. It was an error, but it wasn't an intentional error.
So, he paid taxes every year. He got extensions when he had to. And he even paid penalties and interest.
That's right. So he's all paid up on the tax years at issue now. And he paid with interest and penalties. And he testified that totaled $1 million, the interest and the penalties that he's paid, over the life of these late taxes.
So as we've said, Goldstein took the stand in his own defense. What was his demeanor like?
He was calm and collected. He was a little bit self-deprecating at points, particularly when he was talking about his gambling losses. And this is just my perspective, the jurors may have a different perspective. I thought he came across as very credible. That said, maybe he will come across as less credible cross-examination. But he has not done any violence to his defense yet.
His intent is critical in this trial. So how did he explain what his intent was or wasn't?
So this whole case is turning on what was in his mind. And so the point of him taking this stand, I think, is to fill those gaps. I think one of the most surprising things he testified to is, so he walked jurors through his gambling in 2016 and through this allegedly secret gambling ledger that actually he'd asked one of his law firm managers to email him at some point. Like, it wasn't really the secret gambling ledger, he said. And he also said that the origin of the ledger was because his accountant had suggested that maybe they needed to send 1099s to people he had sent money to for staking payments or gambling losses. They decided they didn't need to ultimately do that, but that was sort of the origin of this ledger. So we walks the jurors through the ledger, and then he fills in some of the gaps and explains like where different errors were, like what he was trying to assemble and why there were question marks in certain places. He also referred to, and the government has objected, and it hasn't made it into evidence, this ledger that he maintained with this guy, Paul Phua, who is one of his former clients, ultra wealthy Malaysian Chinese businessman. And they had this sort of ongoing gambling relationship, and they had this virtual ledger where they sort of tracked everything that they owed one another. So he was able to sort of refresh his memory using that. What he actually reported on his 2016 return for gambling income was $2.7 million. An IRS expert who testified earlier this week, she said he should have reported $6.2 million in gambling winnings on his return. Wednesday, he told jurors that in fact, he should have reported zero income on his tax return because he had screwed up his gambling calculations so badly that he was actually in the negative.
Is that all about the numbers, or is that
all about the numbers and understanding what the numbers meant? So the government's looking at these numbers, but they don't understand whose money belonged to who. So, for example, he might have a money that he owes somebody who staked him, backed him at a game, and say he wins, and he's got their share of the gambling winnings. Sometimes he would have it for a while, and they'd be like, "No, don't pay me, pay that guy." So when the government's just looking at his bank accounts and looking at wires, they're looking at a really incomplete picture. That's sort of what he was getting across. And he was filling in those gaps. And by the time he was done filling in those gaps, the math looked very different.
Were the prosecutors surprised by this, or were they expecting it?
I think they were very surprised. So Jonathan Kravis, again, this is a Goldstein sort of lead defense lawyer. He's done most of the heavy lifting in terms of cross-examination so far, and he did direct. I mean, he almost leapt out of his seat when the government rested to announce that, oh, by the way, here's our printed motion for acquittal and all of the exhibits, and Mr. Goldstein intends to testify tomorrow. And apparently he planned to do this the entire time. There was never any doubt from the defense team that he was going to testify. And the reason I say that the government was definitely surprised is because in the course of making different arguments, mostly about whether or not evidence is going to come in, et cetera, they've said, well, he's trying to smuggle in exculpatory statements. He's not going to take the stand. And so he's trying to get, his own thinking in other ways, yada, yada, yada. It was very clear that the government did not think that he would subject himself to this.
Thanks so much. That's Bloomberg Law senior reporter Holly Barker. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.